What's going on? It is showtime. We are back. Another live November 16th. God, we already in the middle of November. For those of you who don't know, I am Dave, a 10 plus year intellectual property attorney, dealing with everything from patents, copyrights, trademarks, trade secrets. And we got a little bit of everything that's going on here with this live today. We got a lot to get off into. A weekly recap, a couple lawsuits to get off into. We'll pull up the complaint, kind of read it live. They're short, so we'll be in and out. The Lions play at what time is it? 7:15. So the Lions play at 8:20. So I gotta wrap this thing up. Hopefully about 8 o'clock. Go to the cigar lounge, try to catch the Lions. Hopefully they get a dub. They're playing Philadelphia Eagles in Philly, so it's gonna be a good game. I just had to pull myself off the TV screen from Kansas City and Denver. It looks like that one is shaking up to be a good game. Your boy Shador, he had, see, like Gabriel had a concussion, so he came in there. He's not looking too good with a couple sacks and an interception, but hey, man, what you think? Throw a guy up in there and kind of hope for the best. So we got a lot to get off into today. We are talking about Buc-ee's. Buc-ee is back in the news. This time, a company, Nut Huggers, they are standing up to Buc-ee, so we'll kind of play that kind of news, I guess the news broadcast, and kind of give you guys a little bit of my thoughts. I got some interesting thoughts on this one, and I kind of reached out to the Nut Huggers owner, and we're trying to link up here, so that'll be an interesting one. What else do we have here? We have Kris Jenner, the matriarch of the Kardashian family. They say the 70 the new 30 or new 40, whatever it is. Looks like she has kind of filed some trademarks for her beauty line based off some tucks they said that she got. So we'll get off into that. What else do we have here? Some law firms. I'm all for families doing business together. It seems like these legal couple, they were married, formed a law firm. They got divorced, still doing a law firm, and then all hell broke loose. So we'll talk about that trademark battle here a little bit. And interview of the week, we'll start with Shark Tank pitch of the week. Those will be the first two things that we talk to. And then Nike. Nike was sued by a startup company. So these big guys, that's why I named this one, the little guy stands up for themselves. Between somebody, the little guy suing Nike, between the Nut Huggers underwear owner standing up to Buc-ee's, and we all know Buc-ee's been kind of slapping lawsuits on everybody left and right. What they say in Denzel Washington said in Training Day, I'm slapping cases on all you. Look like Buc-ee's been slapping cases, but they ran into the wrong one this time around. So again, a lot to get off into, but as we start here, please hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community. And let's kind of start with the interview of the week, which is Chef James Berry. Now, he was on Shark Tank. That interview dropped this past week. Go check out that full interview. And he has some cool things to share, as well as some kudos that he gave me. But just kind of give you guys a little bit of what he does. He takes organ meat from animals and kind of, produces a seasoning out of it. Again, he was on Shark Tank. I think he got a deal on Shark Tank, but some interesting things that he has to say about this. So let's kind of cue this up and see what he says and kind of go from there. Let me make sure I have this on the right speed.
Felt really grateful. I'm like, oh, this is a good thing he's doing for not only businesses, because you make so many good points on your videos. I watched a bunch of them. I really did. And of course you make a lot of good points, and you got me thinking. I was like, oh, we have a register mark, and I don't have the register mark right next to our logo. And so you got me going like, oh, I got to do that. So, just wanted you to know that I am someone that your work is affecting. So thank you.
Hey man, I appreciate Chef James Berry. I have to kind of let you guys know what happened. So he was on Shark Tank, and as he was on Shark Tank, they were telling him, hey, man, you need to just check out some video, check out some pitches, and kind of you'll be able to get a good feel for what's going on. And as he was kind of doing the pitches, he actually found a lot of the pitches on my channel. So that's what he was talking about in that clip, to say, hey, man, you have really helped me out and affected me, because I learned what I kind of needed to do from watching the videos and your analysis on your channel. He also mentioned that, hey, just from kind of going down the website, again, just your perspective, your advice that you're giving, not advice, but your information that you're giving about making sure you're notifying the public of your trademarks, just different intellectual property that you have protected, to put the R in the circle next to the trademark term. And he's like, man, I had to kind of take some of that stuff from you. So shouts out to you. He gave your boy kudos, man, which is all it's cool to hear, because a lot of times, man, you do these interviews or you do these reaction videos and you kind of do these interviews and you do these current event breakdowns, you don't know if they hitting the audience or the audience is getting information out of them. But that was cool to see Chef James Berry kind of give your boy some kudos. And again, he's a big dog, man. Was on Shark Tank, got to deal with one of the sharks, and he's crushing the game with his seasoning, his superfood seasoning. We all trying to be healthy these days. Health is a big thing, and Chef James Berry is crushing the game these days with his superfood seasoning. So definitely go check out not only the product, but go check out the interview that I did that just dropped this week with Chef James Berry. Again, to the extent that you're just joining, man, please, number one, hit that like button. And to the extent that you're are not a part of the intellectual property family or the IP family, man, hit that subscribe button for your boy as we go on to the Shark Tank pitch of the week. Now, this was Surf School. Let me see if I can kind of pull up this see if I can pull up their website. Man, I was impressed. Actually, I was impressed with a couple of the pitches this week from Shark Tank, but Surf School was one of the ones that I did want to highlight on this one. So you had Forte 3D, which again, Forte 3D is essentially a 3D printing company that prints string instruments. So for all of you orchestra players out here, your boy was in a band myself, play percussion, but if you're violin, cello, any one of those string instruments, Forte 3D prints 3D string instruments so that they're a lot cheaper compared to, and you get them a lot quicker compared to the ones that you'll get from the store that's handmade, that takes months. So, but I think Surf School, I mean, again, number one, he is protecting that not only via a trademark, but he's protecting the device via a patent. You see the guest shark Daniel holding one of the essentially it's a bucket hat with a protective layer inside of it. So if you're a surfer, again, it helps you kind of prevent concussions, head injuries when you are on the waves. And they, like I said, they're protecting it, or they're filed for a patent application. They're waiting to see if they get a patent on it. But kind of based on what I've seen, not only from their pitch, but also some additional research, looks like they have a good chance of getting a patent on their essentially protective headgear for surfing. They have a trademark on the term Surf School as well. So, man, shouts out to these guys. And they got a deal. They got a deal with Daniel. They got multiple offers. You guys have to go check out that reaction video. And I'm going to reach out to these guys to see if I can get them on the platform. But you guys have to start a business. We all have ideals. They got a deal on Shark Tank. They only made $17,000. They only made $17,000 worth of revenue up until this point in time. And somebody took a chance on them on Shark Tank. And I think they got a good deal or a good partner in Daniel. They're going to go, I think they're going to go cool. They're going to be kind of big time. So Surf School, kind of check out the website. I'm not going to go through it in detail, but this is essentially the score that you, the hat that you see here that helps surfers avoid head injuries. Like I said, they were on Shark Tank. They got a deal on Shark Tank. And yeah, I think the product is cool, man. You know, we're in the Midwest. So thus in the Midwest and the East Coast, we're not big surfers, but to the extent that you're checking this out from the West Coast, California, you probably want to go to check out that hat. I was, a little bit of price of the version 2, at least $100, but they have they're protecting it via a patent, and I think with their partner in Daniel, they're going to be man, they setting themselves up for prime time. So with that being said, let's move on to more of the BS. I will say that the BS portion of the show, we're talking about kind of different things that's going on. They said 70 is the new 40. You see in a picture here, Kris Jenner to the left. I'm gonna play this the news broadcast of her filing for trademark protection on her beauty line. Now, we all know the younger one, what I think Kylie Jenner has, Kylie Cosmetics, and that's made her a billionaire. You have Kim Kardashian has Skins, which has made her a billionaire, the cosmetic line. Then I guess the mom, the matriarch, said, hey, I got to get off into it, especially for the older crowd, and kind of come out with a cosmetic lines, which I think is Queens by Kris Jenner. You see the picture to the left is Kris Jenner, the old Kris Jenner. And the picture to the right is the new Kris Jenner. Look at, man, I have a mom that's 70 years old. And Kris Jenner is 70 years old. So I'll tell you what, man, she kind of looked good for the picture to the right. But I'm not sure if I want my mom to get all this surgery to try to look younger. One of the beauties of life is, we all age. One of the, the pros and cons of life, I should say, is we all age. And I want you to take care of yourself, and I want you to kind of, get older or whatnot and still look good. But I want you to do it the natural way, the healthy way. I'm not sure if all these kind of surgeries are kind of the way to go, but this is Kris Jenner here to the right. Is her new look. Let me know if you guys like the new look or if you don't like the new look. And we're going to pull up this news article here so we can kind of see what it is that she has going on. She has filed for trademarks on her new cosmetic line. So let's kind of see what the news article is saying. And I kind of give you guys my thoughts on this one. Let me know where you guys are from to the extent that you guys are tuning in for the first time. Let's kind of pull up the news article and see what the news article is saying about her trademarks. Come on now. Let's go. There we go.
Morning. TMZ producer Christina Cavalieri joining us live this morning. Christina, how are you?
I'm good, Jerica. How are you?
Good, doing good. Apparently not as well as Kris Jenner, who looks phenomenal, let's say. And she's not stopping when it comes to making money.
I know the matriarch of the Jenner Kardashians is really capitalizing on this flawless facelift, isn't she? We've just got a news there.
So she got a facelift, according to the TMZ producer. I don't know what a facelift entails. So you guys have to let me know what a facelift entails in the comments or in the chat. This looks like, it's a little bit more than a facelift. But again, I'm a guy and I'm not kind of in the know with that. But she looks totally different from the left side to the right side. Apparently, it's only a facelift, but I'm not sure what that means. It looks like there's a little bit more going on in a facelift. Let's go.
She's obtained a trademark to Queen by Kris Jenner. And this trademark covers all things beauty. We're talking perfumes, lotions, oils, masks, nail polish, really across all the beauty brands. So it's really not that much of a surprise because of her recent facelift, and everyone is just completely obsessed with how she looks, me included. And we're also talking about the Kardashian family. I mean, Kim has had a beauty brand, Kylie has a beauty brand. So it's really only fair that the momager gets involved in the beauty as well, especially with a beautiful face like that.
Yeah, obviously, her face is beautiful. Hair is still thick. Body looks amazing. At 70 at her party, she looks phenomenal.
70.
Oh my God, where was our invite to this party? That looked insane. I'm talking like every A-lister you can think of. Oprah was there, Prince Harry and Meghan Markle were there, and it all happened at Jeff Bezos and Lauren Sanchez's, should I say house or compound in Beverly Hills?
Yeah, she really crosses over too. Different celebrities. That's awesome. So good for her. All right.
Yeah.
Not so good for Will Ferrell.
We don't care about Will Ferrell, but again, Kris Jenner, shouts out to her. I have to give her a shout out. At least she's protecting her intellectual property. Now, yeah, she has a cosmetic line. She's protecting the intellectual property, the trademarks. But you see here, to the extent that you're tuning in, Kris Jenner to the left, at the picture to the left below is the 70-year-old before the facelift. The picture to the right is after the facelift. I'll tell you what, man, they say 70 is the new 40s, 30, whatever it is, but she's 70 years old, and that facelift is making her look a lot younger, I would say, to say the least. So kind of let me know what you guys think about that. Would you get a facelift? It's something about getting old that, like I said, it's a pro and a con, it's beauty, but at the same time, it's like, man, I got a couple gray hairs myself, and that kind of throwing me into a frenzy, my midlife crisis. But I'm not sure if I'll kind of do the facelift. But hey, look, man, if I was kind of somebody who's looking, and she kind of look good to the picture to the right, man, I'll make a pass at her, even though she's 70 years old. She's half my age, by the way. I'm 35 years old. Now, if I seen Kris Jenner on the street, the picture to the right, Kris Jenner, I may say something, man. She look kind of good. Let me know if I'm tripping on that one, or if to the extent that we have any fellas watching, let me know if you guys kind of share my sentiment. But she looked pretty decent. But again, man, my mom is 70 years old, and I don't know, man. Let's kind of move on here. This is actually an interesting one, and I actually like when families do business together. With one caveat. This is the only caveat I have, and this is a husband and a wife, a former husband and a wife. They were doing business together, and you can see Carabin Shaw. They own law firms. I can tell you, boy, from experience, two lawyers should not get married. I know some out there may disagree with me, and some who are married, who are both lawyers, may be making it work. But I can tell you from personal experience, I do not recommend two attorneys getting married. However, I do like when the husband and the wife come together, start a business, and go from there. But in this case, you had a husband and a wife. They got married, it seems like in 1999. They were, started the law firm, which is called Carabin and Shaw. I think the wife name was Carabin, last name was Carabin. The husband last name was Shaw. And they end up getting divorced in 2003. So just a short time, 4 years. They kind of made it longer than I did. But it seems like after after they got divorced, they were still doing business together, which is crazy to me to think that you can kind of get divorced. Let me know if I'm tripping on this. They got divorced in 2003, but they were still doing business together with the law firm, still running a law firm together. Then it seems like the wife decided at some point to retire. So the essentially the husband bought her out, the ex-husband bought her out, and kind of he was doing his thing. And then it seems like maybe he kind of missed some payments on a buyout, and she wanted to get back into the legal side of things. Next thing you know, that it was Caribbean Shaw. They had a trademark on that. The husband or whoever filed the trademark on a law firm named Caribbean and Shaw. It seems like when she got back into the legal field, she tried to get her last name, which is Caribbean Law trademark. The USPTO denied her, and they cited the Caribbean Shaw law firm trademark, and she tried to petition the court or the USPTO to cancel the mark, and that's kind of where we are at with things. So, look, man, I'm all for spouses, family members, whether it's a parent and a kid, or two spouses getting together and trying to start a business. But you need to make sure that you have your paperwork, your paperwork right. I would have definitely recommended to the husband, the ex-husband, hey man, make sure you put. Hey, if you're giving her this money in a buyout, make sure you're getting the right set of trademark. It seems like he did not do that. And that kind of left this up in the air, gave her an opportunity to petition to cancel the trademark. Because one of the things that people don't know, when you are trademarking a name and it's not your name and it's somebody else's name, you need permission from that person to trademark the name. So Caribbean, the ex-wife, she's trying to petition to cancel the mark, saying that, hey, when they filed the trademark Caribbean Shaw, they did not get her permission to do it, which to me is crazy because, look, if you're running a law firm, you got a trademark, the fact that you know of the trademark and you continue doing business as one of the owners of the law firm, clearly it's an implied authorization to do that. So for her to try to come back years later to say, 20 years later to say, hey, they didn't have my permission to cancel them, to file for a trademark on this term, to me, that's crazy. However, kind of let me know if you guys disagree with me. It seems like we have a comment here. Let me see what, okay, your boy Brandon says. No bueno on the facelift. Welcome to Hollywood. So he's talking about the Kris Jenner situation. And I would agree with you. Yeah, Brandon, I know you're from the Midwest like me in the great state of Michigan, even though you're out in Cali. And I'm not dealing with the facelift either. I just like I like kind of getting old, man. Just make sure you work out and take care of yourself, eat the right things. But in terms of trying to do these facelift and what they, whatever they put on the lips. And I was at a Mediterranean place on Friday. Hey man, all these Middle Eastern girls, they got all these kind of I call them lip implants, but I don't know, they think it looks good, but to me, that shit looks terrible. I just like kind of, just being natural and getting older and taking care of yourself and just letting age do its thing, man. 70 years old, kind of looking 35, 40. I'm with you, Brandon. No bueno for me. But kind of let me know if somebody else disagrees with us. But with Caribbean Shaw, to kind of wrap this up before we go into the next segment, make sure that if you guys are doing business, it's two people, whether it's family members or you with a friend and you doing business, make sure that you have your paperwork right, particularly as it relates to the intellectual property. So if y'all break up or somebody decide to go on their way and you buy them out, make sure it's in the contract that you retain ownership of that intellectual property, whether it's trademarks, whether it's patents, whether it's copyrights, whatever the case may be. And it seems like in this case, like I said, Shaw did not do that, and that left the door open for the ex-wife to come back and try to say that, hey, petition to cancel the mark with the USPTO because they didn't have authorization. Now, I think they're going to lose. However, I think it's some BS. So with that being said, let's move on to the next one. Nut huggers. We're going to play this news article, but your boy got some intel. So I actually reached out to the owner of Nut Huggers. We've been going back and forth. He was going to come on the channel. We was going to do an interview, and we still going to do the interview. But his attorney, given the fact that Bucky just sued him for trademark infringement, his attorney like, hey, man, lay low. I think his name is Jared, something with a J. He like, lay low real quick, man. Let me kind of handle this, and then you can go on everything intellectual property and kind of let them know the story. So he does have a patent on his underwear. But let me know in the comment section. So obviously we all know about Buc-ee's. Buc-ee's has a trademark on their beaver as well as the name Buc-ee's. Your boy, he came up with some underwear, which you see the picture below. It's called Nut Huggers. Seems like it's a squirrel. Like I have to tell you, from a marketing standpoint, This guy, he hit it on the head. He has some underwear called Nut Huggers, and the logo is a squirrel holding some nuts, holding 2 nuts. Shit, I think he going somewhere with that one. But let's kind of pull up the news article and see what the news has to say. Like I said, I have been in touch with the owner of Nut Huggers, and he's going to come on the show. He was going to come on in next week. However, his attorney has told him to just kind of lay low for a second until this trademark situation blows over. So let's kind of see what the news article is talking about in terms of what's happening with Buc-ee's and suing them for trademark infringement or coming after them for trademark infringement. So let's go.
Home of small business getting ready for battle with gas station giant Buc-ee's.
The owner says shortly after he filed to trademark his cartoon squirrel logo, he got a 3-page letter from Buc-ee's saying it looks too much like their beaver logo.
Well, News 4's Adria Goins spoke to the owner of the company, who says he's ready to fight it out over this, Adria.
Yeah, guys, Jared Hewitt started his underwear and apparel brand 3 years ago, and that's when he came up with his logo, which features that cartoon.
Hey, y'all can't tell me that logo is not dope. Now, first of all, let me know in the comments. We know the Buc-ee's logo to the left. You see the Nut Huggers logo to the right with the squirrel holding the nuts. Would you guys be confused as to from a trademark standpoint? Do you think those 2 logos are similar? Clearly, Nut Huggers and Buc-ee's, the names are different, but do you guys think those logos are the same? Do you not only the same, do you think those are confusingly similar? In other words, do you think looking at this Nut Huggers logo with the squirrel with the 2 nuts, you think that somehow related to Buc-ee's with the beaver with the hat on? Let me know that in the comments, because that's essentially what this is coming down to. And we all know that your boy, Buc-ee's been suing everybody. They had one gas station that essentially shut down and turned into a lemonade stand. You have Super Fuels, which is another gas station, I think, in the Texas or the Missouri area. They changed their logo. So Buc-ee's been slapping everybody with these lawsuits and forcing name change and causing these companies to essentially go out of business. However, Nut Huggers, my man Jared's like, man, I'm not having it. This is not trademark confusion. This is not a likelihood of confusion or trademark infringement. This is not a likelihood of confusion. And I'm gonna stand up. And I talked to him. Your boy seems like he's taking this one to the end. But I need y'all to let me know, do you guys think these logos are the same or are they different? That's what this is coming down to. Let's see. Let's finish off this news article.
Squirrel. He never thought he would be battling Buc-ee's over the image and was shocked when he got that letter from them.
If you'll notice, when you open up, there are sides.
So look at those 2 black sides. That's what he has a patent on. I'm telling y'all, y'all got to start a business. This guy has a patent on underwear. See the black side? I guess they keep your man area nice and tucked for the fellas. We know how important that is. But those 2 black kind of fabric pieces that are on the side, that's what he has a patent. He has an issued patent on his underwear, and he's selling them. And it seems like it's going well.
Jared Hewitt says his underwear line is a hot commodity inside the market at North Park Mall.
The last 3 months have been our first.
So I talked to Jared. This is the guy I was talking to this past week. He was going to come on the show next week, but his attorney told him to cool off until this whole trademark issue with Buc-ee's kind of blows over, and then he's going to come tell his story, talk about the patents, talk about the Buc-ee's lawsuit. He's going to give us a whole rundown. So I got the exclusive coming up, but his attorney kind of told him, just kind of lay low really quickly. We know Everything IP is a big channel, big YouTube channel, but let's lay low really quickly until this Buc-ee's stuff blow over.
Profitable months. We've been pre-revenue for 3 years, so it's been really exciting to see it grow.
His small business is called Nut Huggers Apparel.
I love the name.
Concept he created, redesigning the way active people wear underwear.
We went with kind of the tongue-in-cheek humor of.
But the past few weeks have not been funny for Hewitt. After sinking hundreds of thousands of dollars into his business and finally seeing it succeed, he was shocked by an email from Buc-ee's.
The initial request came in a little hot and heavy. They suggested that they owned all cartoon rodents.
The letter stated Hewitt's logo was a trademark.
Hey man, y'all have to. I was telling I was telling somebody Brandon actually earlier today. I got a cease and desist letter a couple weeks ago for one of my clients on the trademark issue. You cannot just oblige, especially if it's a big company. And the cease and desist letter I got is from a big company, to the point if I said the name, you guys would know. But you kind of just can't start kind of making concessions, because if you start making concessions, then it's all they're gonna want to take over the world. I mean, they're gonna start asking for the world. So in my cease and desist letter, hey, we was stern, we was fair, but we was stern. We said, hey, we don't think it's trademark infringement for X, Y, and Z. And now we're kind of going back and forth. And I think our client is going to kind of come out in a good space. But you heard Jared say, hey, they asked to stop doing this. Then we stopped doing that. Next thing you know, they asked to stop doing all this other stuff. We like, hold on. So once you start making concessions or being agreeable, even though you probably shouldn't have, that's it's just not going to be a good day at the end of the day. To say that you have a trademark or you own all cartoon rodents, that's crazy. How many Disney or Warner Brothers, these major studios that have trademarks on rodents, cartoon rodents, and to say that you own all cartoon rodents, again, this guy's selling underwear. Buc-ee's, obviously, they sell clothes, but their main thing is a gas station. So to think that and the logos don't even look the same, in my opinion. Let me know if you disagree with me in the comments, but the logos don't even look the same. So the fact that you're telling me that, hey, we own all cartoon rodents, we protect all cartoon rodents, so can't nobody do it? Hey, man, I call BS on that, but that's just me. Let's kind of finish up with the news article.
Infringement because it uses a cartoon brown rodent character smiling with buck teeth in various depictions. The letter demanded Hewitt stop using cartoons, rodents, the colors red, yellow, and brown, no baseball hats,
nothing like Buc-ee's,
and only front-facing images. Hewitt, who has a trademark of his logo,
and he has a
says
trademark.
He emailed back saying he would stop using specific colors and a side profile of his logo, but even then.
And that's where he messed up. To say, hey, we're going to stop using these colors. We're going to stop showing it in this orientation. Buc-ee's like, okay, this guy, he trying to be too amenable. He's trying to be too agreeable. That's when they said, okay, that's good. And I stopped doing X, Y, and Z. Now, next thing you know, he like, oh, this some bullshit. So, hey, be careful when you start kind of obliging to these demands.
And it was not enough. The gas station giant has sued other businesses in Missouri, South Carolina, North Carolina, and Florida for similar reasons. But Hewitt says what's happening to him is different, and he is up for the fight.
I think that it's time that somebody stands up and says, this isn't right. There's no infringement here. You all don't have a right to be doing this and take away people's local livelihoods.
I called and emailed Buc-ee's corporate office asking them to explain why they felt this was a trademark violation. I also called and emailed Buc-ee's lead attorney named in that letter, but I have not heard back yet.
You're probably not going to hear back from them, but let me know what you guys think, man. I think that's some BS. He's definitely your boy Jared. He's going to be coming on the show at some point in the future. It may be, Q1 of 2026. It may be Q2, but I'm definitely going to get him on. But right now, he's kind of dealing with a legal battle. Hey, be careful. To the extent that you're operating a business, you got trademarks, you get a cease and desist letter, especially for these big guys. When you start kind of obliging, then it's kind of downhill from there. Thankfully, Jared said, hey, man, I'm going to stand up and I'm going to fight these guys. And I think he has a good chance of winning. It may cost him a couple dollars, but he has a good chance of winning. So let me know if you guys agree with that or disagree. And, let me know if you think that the marks are similar or dissimilar. I think they're dissimilar. And it's not trademark infringement, but that's just kind of my opinion. Let's see what Brandon says about this one. The two logos are not similar. I would tend to agree with you, Brandon. Let me know if anybody else who's watching this, you see the logos there. Let me kind of pull Brandon's comment down so that you guys can get a good look at him. He said the two logos are not similar. And you see I think the Nut Huggers, not only the name is sweet, but I like the logo with the squirrel holding the nuts. I think that's a pretty dope logo for what it is that he's selling underwear for men. But you see the Buc-ee's logos up top, the Buc-ee logo up top. I think a beaver with a hat and a squirrel holding two nuts, that should kind of make me mad, to be honest with you, because you're clearly trying to get over on a little guy. And that's why I named this one, The Little Guy Stands Up. Your boy Jared stands up. Then we got, as we move on to this next one, to the lawsuits of the week, we have a couple other people standing up. Nike got sued by a small guy, but let's kind of move on to the chitlin strut. This some country shit right here. The chitlin strut, I think this is a South Carolina situation. And I got some thoughts on this one. Because you can't file a lawsuit. You don't even got the trademark to the what's name. Now, you can do that technically. However, I will always tell you guys, before you try to file somebody or file a lawsuit for trademark infringement, make sure you actually got a fucking trademark. Make sure you file for a trademark on a name at first. Let me know if you guys agree with that or disagree with it. I'm kind of trying to find out what's the name. And hit that like button for the YouTube algorithm, as well as hit that subscribe button. Let me see if this is the right thing. Okay, here we go. The Chitlin Strut. We're going to go through. This is a quick lawsuit, so we're going to go through it here really quickly. This is the town of Sally. So apparently, the town of Sally throws this Chitlin Strut. And before we get to the town of Sally, let me show y'all this one. This town, this is a town in South Carolina. They need to get this in order if you ask me. Because when you go to the Chitlin Strut website, this is what it says. When you go to the town website, this is South Carolina, a town of Sally. The Chitlin Strut, apparently it's a parade that they throw every year. It says the 2025 Chitlin Strut has been canceled to allow the council to restructure and properly strategize for the 2026 Chitlin Strut. So they didn't even have the Chitlin Strut this year. However, they got the nerve to sue somebody for trademark infringement. And they don't have a trademark on a registered trademark on the term Chitlin Strut. Can't make this shit up, man, if you ask me. But let's kind of nonetheless, let's take a quick look at the lawsuit. Let me know what you guys think as we're kind of reading through the lawsuit. It's a quick one, so it should be shouldn't take that long. Shouldn't take that long. Let's go here. Chitlin Strut. Okay, here we go. The plaintiff complains the defendant is incorporated. I'm gonna kind of skip that. The factual, the background. For over 50 years, to the extent that people don't know what chitlins is, just ask a black person. For over 50 years, plaintiff has organized, promoted, and conducted a festival. So they've been doing this for 50 years. Just think about this. You've been doing this for 50 years and you don't even have a registered trademark. You should be ashamed of yourself, the town of South Carolina. But to the extent that you need somebody to file for a trademark, hit your boy up. The town Chitlin Strut has included parades, food and beverages, cultural and entertainment services, and so much more. This is apparently a flyer of the second annual one of 1967. You see the pig there. A second example replicated below is a promotional flyer. So this is another one, the eighth annual one. With few exceptions over more than 5 decades, the town of Sally Chitlin Strut has been conducted annually. Plaintiff enjoys excellent reputation, so forth and so on. Through its long-term and extensive use of the term Chitlin Strut, mark its consistently high-quality services and the success of its festival, plaintiffs have built up a significant amount of goodwill. You know, it's a black guy who apparently Matt Hardy, they tried to bite off the Chitlin Strut. And again, he's in South Carolina as well. You see his flyer. Looks like this is an Instagram page. This was last month in October. It says, so as defendants are organizing and promoting a festival that they have named the Chitlin Strut that is scheduled for November 29th. So this is going to take place later on this year. You didn't look at, man. It's another town in South Carolina. Example of defendants' use of the term Chitlin Strut, including following from the social media. I'm gonna tell y'all this, and this is why this is such a problem. I'm trying to give y'all guys game. The town of Sally did not file for a trademark on the term Chitlin Strut. So really, all Matt Hardy, the defendant, had to do is file for a trademark with the USPTO. Now, they couldn't stop the town of Sally in South Carolina from conducting their Chitlin Strut. However, not only they would have had nationwide rights to it, but the town of Sally could not sue them for trademark infringement because they were conducting the Chitlin Strut. Matt Hardy then was in a separate town, which is apparently is the town of McCormick in South Carolina. So this is why getting a registered trademark with the USPTO is so important, because it's really a first come, first serve. Yes, if I file for a registered trademark and somebody else is already using it, I can't stop them from using it in the area that they were in the geographical area that they were using it. But not number one, they can't expand. Then number two, I can expand in other areas of the country. So that's why it's so important. It's kind of weird that the town of Sally, number one, they didn't have a Chitlin Strut this year. Number two, they've been doing this for 50 years. Number three, they don't have a trademark. That's mind-boggling to me. At some point, you would think that somebody would contact the town and like, hey, man, you probably want to spend $1,000 and kind of get a trademark of the term Chitlin Strut so that you're protected nationwide. The fact that they did not do this, but spent the money on filing a lawsuit against somebody else when they didn't even do the Chitlin Strut this year, that shit is mind-boggling to me. But let me know if you guys disagree with me. I may be in a minority of this, but I think that's stupid. That doesn't even make sense. Seems like this is another one. You know, hey, black people, we're gonna put that sauce on that pig. So it seems like they didn't did it for a couple years. My man Matt Hardy and McCormick seems like this is the second annual one this year. So they didn't did it for a couple years. It started at 9 o'clock. So anybody watching this in South Carolina, you're in McCormick or around McCormick, a 9 o'clock, $25 per grill, $10 per person. So Matt Hardy activities giving the mistaken impression that their upcoming festival are somehow sponsored, licensed, endorsed, and approved by the plaintiff, the town of Sally. Matt Hardy proposed event in their activities relating to it are not and have never been affiliated with the town of Sally. And essentially they're just, that's why they say unfair competition, which, like I said, that shit is stupid. You guys should have filed for a trademark for the term chitlin strut. Like I said, that was an easy kind of in and out. And when I do these lawsuit breakdowns, number one, it has to be kind of somewhat an entertaining aspect of it. But number two, it has to have some type of educational point that I wanted to point out. And for this one, the fact that, like I said, the fact that you have been doing this for 50 years, you are not doing it this year in 2025, and you're suing somebody else for trademark infringement when you don't even have a trademark, that is mind-boggling. Just go file for the trademark. You're going to put yourself in better stance, because all my man Matt Hardy had to do was file for a trademark for chitlin strut with the USPTO. And not only he would have been first to serve, so he would have nationwide protection on it. Hopefully you guys are understanding what I'm putting down, because the fact that a town is doing this, I don't know who their attorney is, but I'm not going to talk about attorneys, man. We have to stick together. So Nike, we're going to end up with Nike has been sued. Another big dog has been sued by somebody for using, you see the picture to the left, that Total 90. That Total 90 is a trademark term by someone who has sued Nike for using it on his shoes. So this is what you should do. You should file for a trademark to get it registered first, and then to the extent that somebody isn't kind of agreeing to your cease and desist demands to stop using the mark, to eventually sue them for trademark infringement. Don't sue somebody and then you don't even have a trademark on it. It's stupid to me. I don't know. That kind of really made me hot for whatever reason. So let's kind of pull up this lawsuit and finish here. And just in time for me to get to the Lions game. I'm going to Churchill tonight. So let's get here. Let me know what you guys think, man. Hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. We got some dope things coming up. I do want to kind of plug the ebook, Got IP. Go check this out. Brandon, if you're still in here, can you please hit that or pin that to the top of the chat, or put it in the chat? The ebook is anywhere from starting an idea all the way up to monetizing your idea. And it's taking you every step in the way, manufacturing, advertising, IP. Your boy, I'm taking my own advice of this ebook, and I'm coming up with a product that I'll be announcing here very soon, a physical product. I'm going to take you guys through each step of this book to show you how hopefully it's going to make $1 million off this. So that's kind of the plan, is to generate $1 million in revenue. And I'm going to be taking you a step-by-step a guide through. I got a Patreon that it'll be all the videos of the manufacturers. I'm going to go to China at some point, going to trade shows. Obviously, your boy IP attorney, so I can kind of do the intellectual property myself. I'm talking to the product design team right now, working with them to kind of design a product. So go check out that ebook. I think it's dope, and it's going to provide a lot of value. So let's get to here. Total 90 LLC is suing Nike, the Nike Corporation, for trademark infringement. Let's get through this one really quickly. Total 90 brings this lawsuit to protect the substantial goodwill it has developed over the past few years. So again, Total 90 has only been around for a few years. They did the right thing in registering their trademark. I'm going to skip jurisdiction and venue and get to the parties. So Total 90 LLC, they are in Louisiana, the state of Louisiana. Obviously, we know Nike is in Oregon. Let's kind of go to the trademark complaint, trademark infringement. At its first ground for relief, Total 90 alleges federal trademark infringement. They sell shoes, shirts, jerseys, so forth and so on. They've been doing this, again, like I said, 3 years, February 24th of 2022. Previous to that, Total 90 developed a soccer application, which started on July 19th or July of 2019. So it seems like they got some type of a soccer application. Total 90 is the owner of 2 federal trademark registrations. Like I said, they actually got the trademark on their stuff. One of those in Class 25, which, again, to the extent that you guys know, Class 25 is clothing and apparel, whether it's jerseys, whether it's hats, whether it's shoes, so forth and so on. Seems like they have it in also in Class 22 as well as 39. Let's go here. The second mark, I'm not sure what's going on here, why that lawsuit just was named. Let's kind of pull it back up here. Oh, man, come on, man. I want to get to what Nike did. I'm trying to get to the good stuff. Oh, here we go. So Nike has filed an application for trademark registration at the USPTO for Total 90. And that mark was canceled in 2019. So it seems like Nike had, and this is another thing that you guys need to be aware of. Nike had filed for a trademark, and it seems like they had it for Total 90, but they canceled it in 2019. Like I said, the plaintiff, Total 90 LLC, they filed for it and got it in 2022. So this is one of the good things that you guys need to be aware of. When you have a trademark, you abandon a trademark or cancel it, it goes back into the repository such that anybody can get it. So it seems like Nike had a trademark for Total 90 LLC, and it seems like somebody at Nike dropped the ball, because typically, even though Nike doesn't, they stop kind of selling a particular brand or a particular clothing with a particular brand, they still keep the trademark active. Seems like for whatever reason, in this case, they canceled the trademark, which is crazy. And obviously Total 90 LLC, they swooped it up. So it seems like Nike sells its shoes and clothing at some of the same trade channels. And this is the plaintiff registration, Total 90 LLC, which is defendants or is the mark Nike trademark as it appears in the application for trademark registration depicted below. Essentially the same thing. So you see here, similar to the shoes that I have here, that has a Total 90 mark on it. This is Nike from Nike's website. You have the 90 there. You got the Total 90 LLC at the back of the shoe there. And without Total 90 LLC consent, Nike has used and continues to use the infringing Total 90 mark and logo in connection with their goods and services. Nike has engaged in infringing activity despite having constructive notice of the plaintiff registration and upon information or belief despite having actual knowledge of the infringement. Nike actions are likely to mislead the public into concluding that its goods originate with or are authorized by the plaintiff. That makes sense. Upon information or belief, Nike has advertised and offered its good for sale using the Total 90 mark with the intention of misleading, deceiving, or confusing the consumers. I mean, again, you have to put all this stuff in there, but I think Nike just like, hey, man, we were using a mark. We canceled it, but we're going to continue to use it. But this is where it starts to get interesting in it. Nike or Total 90 LLC sent Nike a cease and desist letter from its infringing activities, but Nike has not responded to these requests and has failed to comply with them. Total 90 LLC letters to defendant are attached. So I'm not going to pull up the exhibits, but it seems like the defendants were communicating. This paragraph is it contradicts itself. At first, it's saying, "Hey, we sent Nike a cease and desist letter, but they haven't responded." But then later down the line, the end of this paragraph says that we and Nike have been communicating and trying to come to a resolution. So on one end, you're saying that Nike is not responding to us, but on the other end, you're saying that us and Nike are communicating to try to resolve this issue. That doesn't make sense in my opinion. Nike's unauthorized use of the Total 90 mark and logo in interstate commerce as described above constitutes trademark infringement. Like I said, I would agree with that. Based on kind of, you see it, Total 90, and that's what they're putting on the shoe that you see here. You see the Total 90 on the back of the shoe that I have picture here, the gray shoe with the black Nike check mark. You see at the back of the shoe, it says Total 90. That's trademark infringement all day, if you ask me. Let's kind of get back to it though. Authorized commerce. Okay, here we go. Nike acts of infringement will cause further irreparable injury to plaintiff if Nike is not restricted. So they're pretty much trying to get them to stop using a mark. So that's pretty much it on that one. Like I said, that was a quick one. We're going to finish up some of these comments and get you guys up out of here. But look it. This is from this one, number one. Be careful when you start to cancel marks. Because when you cancel marks, anybody can use that mark. Anybody can register that mark. Seems like Nike had, or at least they at least filed for a trademark application on the term Total 90. Seems like they canceled it in 2019. The plaintiff, Total 90 LLC, started using the mark for clothing in 2022, got it registered in 2022. Now Nike is trying to come back with it, and they're like, no bueno. We're going to sue you for trademark infringement. So either Nike is going to have to stop using the mark, pay to license the mark, or essentially kind of get sued and have to pay damages. So that's kind of the options that you have there. Let's kind of finish off. Okay, so yeah, appreciate that, Brandon, for putting the ebook as well as the website in the chat. Let me know what you guys think about this, man. Hopefully you guys are picking up what I'm putting down. The point of these lives is somewhat be entertaining, but at the same time, and I'm trying to give you guys tangible information as it relates to intellectual property, whether it's trademarks, whether it's patents, whether it's copyrights, trade secrets, so forth and so on, so that you guys, as you guys are start the business, that's the whole point of this channel, try to get you guys out there to start businesses and kind of protect the intellectual property and make money. You can do this. Your boy from Shark Tank was school, which I like the product as I pull it up here. They are surfers. It's a niche product because it's surfing, but they created essentially a bucket hat with a hard hat protector inside of it. They filed for a patent on it. They got a trademark for the term surf score, and they got a deal on Shark Tank. So, and they only made $17,000 up until this point in time. So you can still have success with kind of starting your business, going through the process, manufacturing the product. You're gonna learn a lot as you go. Protecting that intellectual property. So again, the whole point of this channel is try to get you guys to kind of start those businesses, protect the IP, and kind of take the information in these case studies, I would call them, to kind of know how to navigate these waters. Because business, it's a dirty game, to say the least. It is a dirty game. So as I to the extent that you guys have any questions, put them in the comments or in the chat really quickly as we close out this thing. Hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community. Again, Brandon, he posted, thanks Brandon for this, the ebook in the chat, as well as kind of the website. Go check that out. Let's see, any more announcements, man? Lions are about to play here in 20 minutes, so I'm gonna definitely go check out the Detroit Lions. They playing Philadelphia Eagles. Gonna have me a stogie. Looks like we don't have any comments or chat questions in the chat. This is gonna be the only time that y'all talk to intellectual property attorney. That's your boy, about $400 an hour it costs to talk to me. So to be able to talk to me and get your question answered for free, y'all got to take advantage of that. Y'all have to take advantages to that. Go check out the Patreon. Like I said, I'm coming out with a product, a physical product, and that kind of the backstory of that product. I'm talking to the product designers now. When I talk to them, all that stuff is going to be uploaded. I'm waiting until I file my patent application. Once the design is finished, I'm going to file a patent application. Then I'm going to start uploading all the videos, me talking to the product designers, me talking to the manufacturers. Funding, I may fund it myself or fund a part of it myself. Another part of the funding, I may kind of look to kind of get funding from somewhere else. So all this is going to be in a Patreon. I'm going to give you a behind the scenes look at this stuff. And hopefully your boy make money. But to the extent I lose all my money, hey, y'all going to be able to kind of know what not to do. So definitely go check out that Patreon. And to the extent that you think it's something that is kind of worthwhile for you, kind of look to sign up for that. So it looks like we don't have any questions here. I think that kind of does it for me. Coming up on 50 minutes, so a nice little hour. Appreciate this live. Hopefully you guys come back next Sunday for another live. And we're going to do these every Sunday. And at the top of the year, I'm going to be bringing on another show that I'm going to be doing live. And that was going to be explicitly on patents. So I'm not going to talk about that yet until we get a little further down the line. But that one is going to be explicitly on patents. That's going to be a cool one. I think you guys are going to enjoy that one. So again, hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community. Thanks again for tuning in to another edition of Live. We're already halfway through November. Your boy is almost at 5,000 subscribers. So again, hit that subscribe button to the extent that you're not subscribed already. Go check out the ebook. I'll catch you guys on the next one. Guys, take care. Peace.